Let's rock and
Okay.
roll.
Sorry, I'm trying to think about how to start this. Okay. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my succinct co-host, Brett.
I've never been succinct in my life, Alice. I appreciate the praise, but it was false praise, and you know it.
I do know it because all I really care about is tying the descriptor to the case that we're covering today. And really, if it describes you, it's just cherry on top. You can be succinct when you want to be. And I've seen your writing in court. Those of you who have read Brett's books know that he is an amazing writer and even a more amazing legal writer because of his succinctness for hard, legal, complex issues. And that's what we're talking about today. Last week or some other week, we talked about the 135-ish page filing by the Richard Allen's defense attorneys in the Delphi case. Side note, Jason, cut this out. You know I'm tired because I was like, what case are we talking about? I was like, it's not Idaho.
Yeah.
Okay, woo, scrap all that. All right. The defense filed in Richard Allen's case in the Delphi case. And we had told you that most of the motion had very little to do with the law. And we, also surmised that the response was going to be short and to the point, and that they should be short and to the point and just talk about the law, specifically about the challenge to the search warrant of Richard Allen's abode. And that's what they've done here. They filed just a couple of days ago their 8-page response. It is bulleted by numbered paragraphs, and they pretty much just stick to the legal standard that is a Frank's motion. And I thought it was effective, but we'll see what you all think as we walk through their response. And wouldn't you know it, I don't think they mentioned Odinites once. Do they? I'm trying to remember.
Shockers, they do not.
I don't think so.
They mentioned the unprofessional filing, or I don't know if it's unprofessional was the word they used, but there's one sentence where they mention the filing and how outrageous it is, but they do not actually go into the Odinites. And, if you guys listen to us when we talked about this, we said this is exactly what they should do. They should respond exactly the way they did. And I just have a couple insights for those of you who aren't lawyers and who haven't practiced law. So a search warrant, I just want to go back. Those of you who watch this on Court TV, it all started with the host and we had a lot of fun. It was a lot of fun. Really enjoyed doing it. His first time on television. It was incredible. Great time. But the host was sort of waxing poetic at the beginning about the Fourth Amendment and how important it is and how serious it is and how when there's a search warrant, it's a serious issue. And that's absolutely correct. And when the defense challenges the search warrant and says the police who are charged with upholding the law and doing the right thing and being symbols of law and order, accusing those people of lying in their affidavit, of misleading a judge, that is a serious charge. And it should be filed in a serious document. And one of the things that irritated me so much about the defense's filing is it wasn't a serious document. And I don't care what you think about the Odinites. I don't care if you think that's exactly what happened. That was not a notice of alternative theory of the law, which at some point they're actually going to have to file something laying out for the court that they want to accuse other people of this crime and laying out the evidence that supports that so they can actually put it in front of a jury. That was not this filing. This was a Frank's motion. And a Frank's motion says the police are corrupt. That's essentially what it says. The police lied. The police misled the court. And they do that because when you have a search warrant and you look at the face of the affidavit, if you can't challenge it on its face, you can't challenge that warrant. And you hear some people talk about this warrant and they're really talking about the face of it. They'll say things like, well, was it really enough that he was there? Was it really enough that he had guns? Was it really enough that he had knives? That is not what we're talking about because that question has been answered. It was good enough because a magistrate judge signed off on it. And even if you question that, the police are entitled to rely on what the magistrate judge says. And that's why you have a Frank's motion, because you have to accuse the police of doing something corrupt in order to reach it. And when you see a 135-page motion that doesn't get to the point until page 105, that does not mention the law until page 135, you know it's not a serious motion. And when you are practicing, and a lot of you who have practiced have done this, you get a motion like that and you send a message to the court in how you respond. If you write a 100-page response, you're saying to the court, these are serious allegations. We take them seriously, and here's our serious response. When you file 8 pages, you are saying to the court, that's absurd. We are not worried about this at all. Neither do you. Here is bullet points. We're not even going to write paragraphs. That was the other thing. They didn't write in a narrative way. They just did bullet points. Here's some bullet points that refute this in 8 pages. That is all this deserves. And that was a smackdown by the prosecution.
Absolutely. Form is incredibly important. And just the form of the prosecution's response here speaks volumes. The substance, we'll get into that, says a lot. Actually, it says very little because it only needs to say very little because the actual Frank's motion said very little about the Frank's motion. And so this response, but the whole form also is speaking volumes here. And Brett's exactly right. When you focus your attention on what the court is supposed to look at and don't get distracted by the smoke and the, fantastic, by the way, odonites aren't even real. I think our friends at Murder Sheet have shown us that. It's a type of rock. So if you're going to go, collect some rocks, fantastic for you. But odonists are something. But whether it's odonites, odonists, I think that even goes to show that the defense hasn't, is blowing a lot of smoke. And the prosecution here is saying, we are going to push that smoke aside and look barely at the law here because that is what is before you, court. And in fact, they're not trying to make their point with exclamation points. That is very effective as well. The prosecution is speaking in essentially lower caps, while the Frank's motion was all in upper caps, font 58, exclamation point, exclamation point. And sometimes rhetorically, you do that when you don't have an argument.
And I just want to say, people keep saying things that are true but don't apply to this issue. It is true that a defense attorney owes absolute loyalty to his client. It is true that a defense attorney has a constitutional responsibility to defend his client to the utmost degree. It is true that if there is a viable alternative argument, the defense attorney has the duty to make it. None of those things mean that this was the appropriate vehicle to do it in, that this should have been a public filing, that it should have included gruesome and graphic details of how the girls died, that the court hasn't even ruled on whether or not that's relevant and should come in, that it should have included the names of the alternative suspects, that it should have included the names of officers that it's accusing of lying, and not only officers, but also correctional officials. None of those things were required or even appropriate because of the duty of the defense. The defense will have an opportunity to present all of this at some point if they can back it up. And that's the other thing. Before the court is going to allow them to present this to a jury, the court is going to look at this and say, does this have any basis? You can write whatever you want in a document. And as long as you're not literally making it up out of whole cloth, you're not going to get sanctioned for it. You're not getting in trouble for it. You can do that. But there is a process here, and the court is a gatekeeper and performs a gatekeeping function. And that keeps cases from turning into circuses. And that's what the defense is trying to do, is turn this case into a circus.
And we always say that when you practice before a judge, you have to keep in mind that it's not just one standalone motion, because the way courts work is that you have one judge who sits through all of the entire case, which includes all of your filings. Every time you argue before the judge, unless there's some certain cases you can get sent to like a magistrate judge who may help out with certain motions. But generally, all of your credibility is in the kind of the entirety of the case. And this is important because, as you may know if you've been following Delphi, there's this fight right now as to whether to allow cameras in the courtroom. And while the prosecution is not addressing all those other arguments in terms of the defense is just trying to make a circus of everything, they are able to address it in the fight about cameras in the courtroom. And you know what? The defense is kind of shooting themselves in the foot when they're filing a 135-page motion, telling this fantastical story and throwing out names, preemptively before anyone has been able to rule as to whether these kinds of names and these allegations can come in. And they are already grandstanding. They're already making the point for the prosecution as to why there may be concerns about cameras in the courtroom. So we're not talking about that motion today, but I think it's important to know the interaction of all of these motions. These motions were all filed, I believe, on the same day, or at least very close in time to each other. In any event, they are ruled on and read by the same judge. And that's relevant here because the judge doesn't live in a vacuum. And there's no requirement that the judge kind of be devoid of all of their interactions with the other filings in this case, with the other attorneys in this case as well. So note that as we're talking about just the Franks motion today, we're also able to take into account the totality of the defense's actions in this case so far.
And let me just say this about the television cameras in the courtroom. So, we had some discussion yesterday about why would the prosecution oppose this? Why would the defense want it? This seems so unusual. Usually it's the opposite. There's a very simple answer to that. The defense knew that if they filed a motion to have cameras in the courtroom, which never happens in Indiana, there's been a pilot program for it. That's about it. They haven't really ever done it. If you're going to do it, this case, probably not the best one to start with, given the intense focus that's going to be on it. But they knew when they filed that the prosecution would oppose it, would feel duty bound to oppose it, would feel like they had to oppose it because of the family, because of the victims. And they knew when they did that, they would be able to say to the press, they want to make all this secret. They want to do all this in the shadows. They don't want you to know the truth. The defense is playing the press like a violin. They have done it in every single filing they made. They did it in the prisoner of war filing. They did it in the Odenite filing, and they did it in the cameras in the courtroom filing. These guys, I don't know what they're like in the courtroom, but when it comes to sort of the public-facing nature of this, they are playing the press, and they're doing it with a gag order in place. It's really kind of impressive how well they are able to manipulate the reporting on this case.
And that's a great point. They know exactly where the press is going to fall out on whether there's cameras in the courtroom. Of course, the press is going to want cameras in the courtroom because it's going to be better for ratings. Are you kidding? Any YouTube channel that streams the trial or has, real-time reactions to the trial is going to get insane amounts of viewership. They know this. But remember, that, I know now we're talking about the filing from the prosecution. The courtroom is open. Every courtroom is always open. Of course, this particular courtroom, when it goes to trial, if it goes to trial, is going to be packed to the gills. But this is not a sealed courtroom. There's no secrets. No one is forbidden from reporting from what happens in the courtroom. But the filing itself was a way to get their narrative out there that somehow the prosecution's trying to hide something from the public. When, in fact, when you have a pilot program, the very first time you do something is in a case of international interest and also has some of the most sensitive witnesses, allegations, and involves minors and, families of the victims who are living their worst day over and over and over, and then maybe go home and have to watch the worst day of their life played out over and over and over again. These things are all relevant to consider. And, a lot of people are like, oh, how hard is it? You just plug in a camera and let it go. Absolutely not. Those of you who watched, say, the Murdaugh trial know that during sidebars, during every time the jury comes in and out to protect their identity, cameras had to be faced the correct way. When there were particularly sensitive or gruesome evidence on the screens, they had to be blacked out or correctly pointed away from the camera. Especially when you don't do this all the time, anyone who's ever operated a camera before can tell you it is not as easy as plugging in a camera and letting it go, especially when there are certain parts of the trial that should not be heard by the jury, certain parts of the trial that should not be seen by the world because of sensitivity issues, especially to do with minor, to do with medical records. Really there's a long list of things to do, but it is not as simple as just turning on a camera and letting it go. And to try this, actually what I would be afraid of to try it in a case like this is the high potential for a mistrial because of something that a juror overhears. The camera suddenly is blasting what's happening in the sidebar, and it somehow is able to blast where the jurors can all hear. Potential mistrial? That would be horrendous after, say, let's say it's the second to last day of trial or something like that. And the chances of that happening are not insignificant.
Yeah, and like, look, I get it. I, I I don't want to be sleeping on one of y'all's couches either in Indiana when we cover this case because we have to go up there because we can't watch it on television. And I get everybody wants to see it. Murdaugh's instructive. You know, they accidentally showed the jury. They weren't supposed to do that. They showed the jury. They accidentally showed photographs of autopsies. Weren't supposed to do that. And oh, by the way, I don't know if anybody has noticed this, but a few weeks ago, the Murdaugh people filed a motion seeking a new trial because the court clerk may or may not have influenced the jury. I wonder if the fact that she was on television all the time and developed a cult following because of her hair had anything to do with her aspirations for writing a book and possibly attempting to corrupt the jury. There are risks and there are costs.
And remember, while the jury is supposed to be sequestered and not listen to what happens in the world, we know how difficult it is to not accidentally see a clip of something. Imagine you're driving down the road, and nowadays we have these billboards that are like TVs, right? They're not just a painted billboard. I know billboards that I drive by switch from different clips, and sometimes they're video clips. With a trial as intensely focused as Delphi will be, you can imagine a juror driving down the road accidentally sees a clip of the trial or a clip of a commentator about the trial commentating on some witness on the stand as a TikTok video at a red light. What is that juror supposed to do? They certainly didn't seek it out, but they saw it. We live in a very connected world. Keeping kind of those clips out of the jury pool, out of the jurors themselves, so that you don't have a mistrial is very, very difficult. And second of all, while the jurors have to be sequestered, no one else, and by the way, I'm sorry, not every jury has to be sequestered. I believe this jury is going to be sequestered because of the amount of intention. And what sequestered means is you take extra steps to make sure that they don't have connection with the outside world. It could mean taking away their phones. It could mean that they have to stay in a hotel. So let me make that clear. Not every jury has to be sequestered. I think with this case, they probably will have to be. With that said, while the jury is not supposed to go seek out coverage of the case in real time, no one else involved in the trial has to. The witnesses do, but not the attorneys, not the people sitting in the gallery, not the rest of the media, not the court employees. So there can be a lot of influence of people who are very close to the trial who may or may not just kind of seep in what the media is saying and then unconsciously exude it out to those who are not supposed to be experiencing that sort of commentary.
And look, there's going to be a lot more discussion about this. It'll be interesting to see what the judge does. I expect the judge will not allow cameras in this, but you never know. We'll have to see. That would be an interesting hearing to hear. One thing they talked about in the filing that you talked about, we're in a new world. They talked about AI and AI recreations, and I was like, oh, that's something I hadn't thought about. But anyways, Frank's hearing. Let's go back to the Frank's motion. We very easily get off topic.
This comes full circle though, because I think the fact that the Frank's motion is 135 pages and we are now all talking about Odinists and maybe the Rock Odinites shows you that one filing where there's not even cameras can have a huge, huge implication on the narrative in the public and your potential jury pool. So with that, let's actually turn to the defense's response on the Frank's motion.
Yeah. So remember, what is a Frank's hearing? I think it's Frank's versus Delaware, if I remember correctly. And basically, as we said, almost impossible to challenge a warrant. Constitution requires a warrant for a search if the warrant is supported by probable cause. Probable cause is determined by an affidavit filled out by a police officer that gives enough information, but not necessarily all the information known to the investigation, to support probable cause that there is evidence of a crime at the location to be searched. It's as simple as that. Unless the affidavit is just so bare bones that no reasonable person would consider it. Like, I believe, based on 20 years of experience, there will be evidence of this site at this location. I have a hunch, and my hunches are always correct. that is not enough. Those are not facts that spell out with specificity why there would be evidence at that location.
Another example of that would be like using statistics. Like, uh, generally, 1 in 4 women, I'm making this statistic up because I don't know the actual statistic, but like 1 in 4 women are victims of domestic violence from their significant others. Therefore, because we have a woman victim here and they have a significant other, I should get a warrant for their significant other. That, for example,
Right.
would not pass muster.
Yeah, that on its face isn't good enough. No reasonable magistrate judge would accept that, and no police officer, if they got a warrant from a magistrate judge, could reasonably believe that that warrant was worth anything. Unless you can do that, the warrant's good. And you only look at the 4 corners of the affidavit. That is a hard and fast rule. So in order to get out of that, to get away from that, to challenge the affidavit, you have to allege intentional a lie, essentially, a lie by omission that is the result of that is intentional, that is reckless. It can't be negligent. It can't be that you just messed up. It can't be that you misspoke. It can't be that you didn't know all the information. In fact, there was information out there that challenged it. It has to basically be intentional or reckless. You put it in the affidavit or you leave it out, and it is so significant that if the true information were in there, or if you'd put the thing in there, the magistrate judge would have looked at it and said, no, there's not probable cause here for you to do this. It's hard to even come up with a good example. I don't know if Alice is good at examples of a lie is easy. Okay, so imagine you say, we believe there's drugs at this apartment. We had someone who conducted a controlled buy there. And later on, it turns out there was no controlled buy. It was just you heard through the grapevine that someone purchased drugs there. So that's not a controlled buy, because a controlled buy is someone you send out. Usually they're mic'd up, whatever. You can follow them. That would be an example of intentionally misleading the magistrate in a way that would lead them to issue the warrant. And if that was the only thing you had, you couldn't get there. Bob Mata, if you guys went to his crime con discussion, I want to have him on to talk about this because it's really interesting. Talks about the search warrant for John Wayne Gacy's house. And the search warrant included that they had found a receipt in his trash can that came from inside the house that was a receipt that one of the victims had. It was in his name. And so since there was a receipt that came from inside the house, that indicated there would be evidence of that person's murder in the house. And then he says he was able to nail down that, in fact, that receipt came from somewhere else. And when the police filled out that affidavit, they actually misled the magistrate judge. And that was the single piece of evidence they had to get inside the house. That's an example where if you had a Franks hearing, your affidavit would go away and you would be in a situation where the search would go away. So that's the kind of thing you have to allege. So the first thing you do is you look at the affidavit and you see what kind of information do they have. Is it something where there's one piece of information like that, or is there a lot? In this case, the things they laid out essentially were Richard Allen came to a resource officer shortly after the girls went missing and basically said, I was on the trails. I was on the trails at the exact right time. I was seen by 3 girls. I was wearing exactly what Bridge Guy was wearing. And not only was I on the trail, I was on the high bridge, but I didn't see anything because I was looking at my phone.
So a lot of things to say right there. Remember, this is in February 2017. And so this is the first interview that he does. And they lay it out pretty early on. And one little thing, just like as a form, I really love form. And I just want to point out, remember how we keep noting that Frank's, the legal standard wasn't even noted to like 135, page 135 of the Frank's motion by the defense. I bet you they formatted the prosecution's response to have the last line of the first page include Franks versus Delaware so that they could have the legal citation on the very first page. That's just a small, I don't know if they did that on purpose, but I would have formatted my brief to do that just to kind of stick it to, the defense to show like this motion is actually about the legal standard. And that's really powerful to lead with because that alone, we have close in time, you have an interview by the defendant. Yes, the interview by Richard Allen, where he wasn't even sought out. He approached someone. So, I mean, that there's some additional heft to that there. He's not sought out. A lot of people were being sought out to be interviewed. He actually approached someone and he gave this story back when the whole timeline and the whole story hadn't really been released to the public yet. He gave his first initial story, and a lot of people have asked, why would he do that? Well, we've talked a lot about this. Remember, there were witnesses who saw Bridge Guy. So when because you've walked that path and other people have seen you who were not Abby and Libby, so they are alive to tell the story, isn't it better to get ahead of the story and be like, yeah, of course I was there. We see this a lot. Remember? We've heard this story a lot. You'll probably find my DNA in that car because Susan gave me a ride last week. Of course, my hair or my DNA is going to be in the car. I was in there last week, though, but I had nothing to do with the murder. So he knows he's been seen. Instead of waiting around for the police to then come and either execute a search warrant on his house or come with a preformed view as to who he is, that he's Bridge Guy, he's going to go ahead and put it out there. A lot of people on this trail. I was just one of them.
And, there's so many examples of this. Those of you who think that John Ramsey was involved in the murder of his daughter believe that the reason he found the body and the reason he picked the body up and took it upstairs and put it on the ground and then Patsy Ramsey threw herself onto the body is because they were involved in the murder, and this was a way to account for any DNA on her body. We just talked about in our other podcast, we just talked about the disappearance of Brianna Maitland. And in that case, her ex-boyfriend says that he was driving down the road, he saw her car, he stopped, got out, turned off the lights, and closed the door. That also is awfully convenient, because if he was in that car, he can explain why his DNA and fingerprints were present. It always amazes me that people say things like, well, if he did it, why in the world would he put himself there? People do that all the time because it confuses the issue. They're trying to confuse the issue. They want the police to think this guy must be a good guy because he's telling me that, he's telling me that he was there. So clearly he's not involved. Another place we see this, I just did a training recently with some police officers, and we were talking about searches of vehicles. And one of the jokes I made that always gets a laugh is that if you ask someone, can I search your car? And they say no, there's nothing in that car. They're completely innocent and you should just let them go. If they say yes, you're going to find cocaine. It is amazing. Every single person who ever has anything illegal in their vehicle, if they're asked, can I search it, will say yes. And I think the reason is they're hoping that the officer will say, well, I'm not going to waste my time then. If you're fine with me doing it, clearly there's nothing there. You can go on your way. That's what they're hoping will happen.
That's a great example, Brett, because now that I'm thinking about like every possession case that I have, if it starts with a search, almost always the person driving the car who stopped for a traffic violation is like, yeah, search my car. And I'm like, why would you say yes when you had like a distribution amount of cocaine in your back seat with baggies to, distribute it and scales? And they're like, I don't know, man. But it happens so often. Obviously, that's a slightly different context, but we see that a lot. And again, I think this is very important to note that in February 2017, there was just very little known about this. The video hadn't come out yet. He put himself in the same clothes that we ultimately know Bridge Guy is in. And by the way, I do have to note this part. We've said this in our Delphi episodes on the Prosecutors podcast. I think 80% of men in Indiana have a blue Carhartt jacket and jeans and some sort of hat because it's a cold day. So by the way, stop doing those side-by-side comparisons. The fact that he accurately notes what he's wearing, I think is so boring, because in his mind and in everybody's mind, who doesn't have a blue Carhartt jacket and jeans? It's like the most boring outfit, and it could be one of hundreds of men in the area.
The first time we talked to Kelsey, we asked her what she thought about the sketches. And she said it looked like every other guy in Delphi. It looked like every single person in Delphi. And I think that's true. And you've seen that with sort of the new suspects, quote unquote suspects, right? You look at them and it's like, yeah, that could be Bridge Guy. And I think it's just true. I think most people in that area of Indiana, that is what they look like. And that's one reason the sketches just weren't that helpful. Even when you look at Richard Allen, then you look at the sketches, you're like, oh yeah, especially the first one. He definitely looks like the first one. If you kind of combine the two, you get him, right? But I think the reason for that is that probably would have been true of whoever they ended up arresting. But anyway.
And by the way, I think that's why he approached a resource officer. He did not approach the FBI. He did not approach like the lead investigators of Indiana State Police. He essentially went, I mean, I'm not saying that the resource officer wasn't helping here. They were pulling in agents and law enforcement from every corner. But a resource officer is someone who probably typically deals with loitering in the park, maybe smoking and smoking illegal substances in the park, that sort of thing. Probably he knows, not the lead investigator of a double homicide. That's who he approaches. I think that's important. Puts himself on the trail because other people put him there too. Puts himself in an outfit that is super boring. Everybody has that outfit. It's not like he says he notes something that's very specific about himself. The things he notes about his clothing, it just happens, we now know, matches the exact outfit of Bridge Guy. I mean, he puts himself there at the time the girls were abducted in the clothes of the person who is on one of the victims' phones, and it's very likely the perpetrator. And this is much more than probable cause. Uh, it could turn out all to lead to nothing in the end, but we are not talking about the standard at trial, which is beyond a reasonable doubt. All you have to have is probable cause that evidence of a crime is at this location. You don't even have to believe that Bridge Guy or Richard Allen is the perpetrator. You just have to have a reasonable, probable cause that he will have some sort of, elements of the crime where he is. And by putting himself there, by his own words, in the clothes of the person who is caught on the phone of one of the victims, you can imagine why a reasonable judge would say there is probable cause here.
We're going to keep talking about it, but Alice has just finished the episode because, once again, step 2, whatever you think was misstated or not included in the affidavit, step 2, before you can even get to an evidentiary hearing for a Franks hearing, is if that was different, if that thing in the first thing was different or not in there or included, would it defeat probable cause? And the problem the defense has is what Alice just said. It is enough if all the affidavit had said was Richard Allen spoke to a conservation officer. He said he was there at the right time. He was wearing exactly the right clothes. We talked to him later, and this is the second part. We talked to him later and asked him, do you have any guns? He said yes. There was a bullet found between the girls. That's enough. That would have been enough as an affidavit to support probable cause for searching his house. And any errors, anything that was omitted, anything that was included incorrectly, which is what the defense talks about. The defense talks about some other witness testimony, some other people and what they said, and how the police said, well, she said he was wearing a light blue jacket, but in fact, she just said he was wearing a light jacket and maybe even a light tan jacket, and that's not blue. All that stuff doesn't matter because the police have that, and that alone is enough.
And a lot of you are probably saying, okay, but that was only the 2017 interview. Don't worry. Directly under, if you're following along with the state's motion, directly under where they say that in 2017, Richard Allen himself put him on the bridge at the time the girls were abducted in the clothes that we now know to be what Bridge Guy was wearing. They say immediately under that. And in October of 2022, they don't delve into all the details because a lot can change in terms of memory or having a motive to change your story 5 years later. They say that when they talk to Richard Allen, he is free to leave. He voluntarily comes to talk to them. And do you know what the 2 important things he says there? Yeah, I was still on the trail. Doesn't really matter, guys. He didn't say he wasn't on that the times. It doesn't matter what the times were. He doesn't deny he was on the trail. He doesn't change his story. He says he was on the trail again. And second, he again says he is wearing those clothes. I mean, that is confirmation 5 years later. He doesn't change his story in that he's still there. Remember, we talk about this in other cases where stories change after the fact. We say this in the Adnan case, that Adnan changes his story later, but what he doesn't change is like the core. The core, maybe the times move around a bit. We're talking about like an hour, 30 minutes or here and there. Even if his times were slightly off in 2017 from the time of abduction, I think you'd have probable cause because you're putting yourself around the time of the murders, of the abduction, at the scene of the crime, in the clothes. People get times wrong all the time.
And some of you may be thinking, what about exculpatory evidence? You have to include that. And if you don't include it, is that a problem? Well, yes, to an extent. It has to be exculpatory evidence that is related to the probable cause. So, for instance, all this Odinite stuff, no, you don't have to include any of that in the search warrant. Because remember, all you're saying is there is probable cause will find evidence of a crime. Maybe it is an Odinite murder at the time, unless you know that Richard Allen has like some sort of, he has like a collar around his neck, and if he's involved in Odinism, it'll go off and blow his head off or something. Like, unless you know that, it would have to be that strong. Then that, for all you know, he is an Odinite. For all you know, he's a secret Odinite. For all you know, he wants to be an Odinite, and this was his way to get in, right? Like, the Odinism stuff doesn't actually have anything to do with whether or not Richard Allen could have been involved in this crime, and there could be evidence there. What you would need, imagine for instance, that he said all that about being there and the stock ticker and everything else, right? And imagine you ran his phone. You'd already looked at his phone records, and his phone records pinged a tower in Delphi Park, but the last ping was at 1:30. And then the next ping was at 3 o'clock somewhere else. So a big gap. But that's exculpatory in that maybe he got his times wrong. And now you have this data that seems to show, yeah, he might have been there earlier. We don't have perfect information for the relevant time period, but we've got him way earlier there. And then around the time period, he's somewhere else. That is the kind of thing that you might need to include in the affidavit. You might want to say, although Richard Allen says he was there and the police believe he was there based on everything he says, there is evidence of cell phone ping data that puts him somewhere else at 3 o'clock. And essentially what you're saying to the judge is, look, this exists, and this is potentially exculpatory, but it's 3 o'clock. We want to make you aware of this so you can make a good faith probable cause determination, but we don't think it defeats probable cause. You kind of saw this in one of the Delphi affidavits, or not Delphi, in one of the Idaho affidavits. And we talked about this, and people got confused about this. There was an affidavit, I think it was for a search warrant, where at the end they say, hey, there's some DNA evidence. We think it's actually inculpatory, but we don't want to include it as a basis for you making the probable cause determination, just in case one day somebody kicks it out. But just in case it's actually exculpatory, we're going to include it here, basically just to cover ourselves, so you're aware of it, and nobody can ever say that we didn't include this DNA evidence that's possibly exculpatory. And it was a little weird, and it really was them sort of going above and beyond. I don't think they had to do that, but that's what they were doing. They were including that information in there just to cover themselves. The thing is, there's not really, you don't have that so much in this case. The best thing you have is Richard Allen changing his story and saying, oh, I know I said before I was there till 2:30, but now that I know exactly when the murders happened and what you're looking for, actually I left at 1:30. That's not exculpatory. The defense can argue that's exculpatory if they want to. That's inculpatory, because when you change your story, when you realize there's a problem, that always makes it look like you're lying.
And look, the prosecution doesn't delve into all of this, and this is basically the facts that they lay out for probable cause, because that's what their probable cause warrant was. But they also note for the rest of us that this doesn't mean this is the extent of all of their evidence, because if you remember the Franks motion, there was all this huffing and puffing by the defense. There's not even a single thing that ties Richard Allen to Odinism or something like that. And they're saying this is page 5 of their the prosecution's response, where they say, by the way, in case you forgot, Indiana Code 35-33-5-2 specifies the minimum information necessary to establish probable cause, and they list out what needs to be said, and it's a minimum bar, and they're saying this blows the minimum bar out of the water. Of course there's more information, but as we've talked about, and you all know about probable cause affidavits, is you usually have a line in there where it's like, there's this is not the totality of all the information that has been learned in the investigation, but this is the information that we believe established probable cause. And that's because the investigation's ongoing. There's a lot. You don't need to confuse the issues. This evidence is already very strong for probable cause purposes. We don't then need to go down all these rabbit trails as the investigation is still going on for purposes of the search warrant. So, of course, the search warrant isn't your entire case file opened up. because the case file probably has a lot of different leads that you're still investigating and trying to figure out how they work together. And you don't want to be in that situation, like Brett was saying earlier, where as certain leads may end up being dead ends, that they if your search warrant was based on it, somehow it can affect the probable cause of your affidavit.
And one thing I want to note, because I think it's important, and I think people get confused by this, and I can understand why, because it's in the defense's motion. The defense makes a lot of trial arguments. They're not actually Frank's motion arguments. One of them they make is that, look, conservation officer doesn't know what he's doing. He messed up all sorts of stuff in his report. He's probably wrong about all this. You really should believe Richard Allen when he says he left at 1:30 because he probably messed up the time. That is a trial argument. That is an argument they will make to a jury. It is not an argument that defeats probable cause, because remember, it has to be intentionally misleading. No one is arguing that the resource officer back in 2017 intentionally lied in his report, which he then hid for 5 years and only discovered then in an elaborate scheme to frame Richard Allen. No one is making that argument. Yes.
Can we just say really quick, if he really did lie 5 years ago, he's a terrible liar, because why would you just let it maybe never be discovered? The whole point of lying was to then frame somebody, and then you're like, "Well, we'll just see if he gets framed in 5 years." Like, I I mean, I'm sorry, that argument seemingly just flies over people's heads. But like, if in fact it was intentional, and it's important for purposes of the Frank motion that it be intentionally lying, then Officer Doolin, it's a strange way to intentionally lie. You lie in your report and then hope nobody ever finds your lie, because what was the purpose of that lie then?
And let's be clear, even the defense attorneys who are arguing there is some sort of odinistic child sacrifice happening in the middle of the day in a public park are not even arguing that he's lies. They're just saying he's incompetent. And that's not enough. And that means that the officer who wrote the affidavit can rely on that. If you can say he's wrong, fine. I think he's right. I trust him as a fellow officer that he got his report right, and I'm going to include that in my affidavit. That is perfectly reasonable.
And by the way, this is exactly what happens at trial. It is totally, I would expect this line of questioning from the defense is any sort of report where the times matter. I'm going to get that officer on the stand, and in cross examination, I'll say, "Do you actually remember writing this report 5 years ago?" "Yeah, vaguely." "Do you remember Richard Allen telling you that he was there from 1:30 to 3:30? "Not really." "Then how do you know it could have happened?" "Because I wrote things down right away." "How close in time did you write it?" "I write it within the day. I never leave the office until I finish writing all the reports for the day." "But you can't sit here today and remember that he told you he was there from 1:30 to 3:30. "No, but I know I can trust my report because I took detailed notes at the time of the interview, and I know that I wrote it close in time at that time. And in fact, whenever I write notes, I show it to the person and say, 'Did I get this right? This is your name.' And also there. Yes, I make typos sometimes, but I have no reason to believe that the times are wrong here because of my usual practice." That is all trial argument. And the jury hears all of that. The jury can choose to not believe Officer Doolin after that back and forth. If he doesn't stand up very well to cross examination, they can say, "Man, that guy was terrible at note keeping. That's probably totally wrong. He misspelled the guy's name. I'm not going to trust him." The jury can decide that, and that's an argument that the defense can make to the jury, but the jury ultimately can decide for themselves after hearing both sides whether they can believe the report or not. But it's not in an evidentiary Frank's motion as to whether that report can be attacked right now. That's fodder for cross examination later. Absolutely.
And I get it. Everybody wants to argue about the heart of the case right now. Everybody wants to do that. And we were on Court TV. That's what they want to talk about, and we refuse to talk about it because we are not going to fall into this trap. Okay, there is going to be a trial. The prosecution is going to put on evidence. They have more evidence than you have seen, and they're going to be able to go back and forth with the defense, and then we'll find out what happens, whether or not Officer Doolin is right, can be trusted, is incompetent, is a issue for court. It is not an issue for this motion. And since it's not an issue for this motion, the motion will fail. And I think this is so important for you to know. Read the prosecution's response. They don't even bother with the things the defense points out because they don't matter. It does not matter. For instance, I'll give you an example. The defense says in the affidavit, it says that this one woman saw a man who was muddy and bloody walking down the road. He looked like he'd been in a fight. And they're like, aha, aha. In the original report, it only says muddy. It doesn't say bloody. He lied about that, which a couple things about that, because we always see this. Everybody wants to act like every single thing is intentional and it's a lie and it's the most malicious thing ever. You have an officer who hears a lady say, I saw a guy, he was covered in mud and he looked like he'd been in a fight. What is the officer when he's writing the affidavit? What's he thinking? Well, if he looks like he's been in a fight, I guess that means he's bloody. He looks like he's beat up, right? Like you can totally see an officer writing that down in an affidavit based on what she said. It's not pernicious. It does not 100% reflect her exact words, but it's not pernicious. The other thing it's not is material. Whether the man walking down the road was bloody or not does not go to whether or not there is probable cause to search Richard Allen, who puts himself at the scene of the crime at the time, whether or not there's probable cause to search his property.
Yeah, absolutely.
And there are other things about it. Like they talk about the one lady, they talk about the sketches and how the one lady, she gave a sketch and it was a much younger man and the police didn't pay attention. It took him forever. Okay, who cares? That's going to be a great argument when you have your trial. You can say it was a younger guy. It wasn't our guy. Look at the sketch. And you can put her on the stand and she can say, I know it wasn't him because it was a guy who looked like he was in his 20s, not him. Okay, fine. That'll be a good trial argument. Doesn't matter for the purposes of the search warrant.
And I know people
What
are
color? Go ahead.
I know people are going to misconstrue this, but we've said this a million times and somehow people just don't hear the things that we are saying. No, we're not saying that those things don't matter. That's all for trial. Like, absolutely. There are going to be issues, and this is going to be a very interesting case because it is not, there are things to cross-examine on. Absolutely. This investigation was not whistle clean. We all know this. We've been along for the ride for the last, 5 years. So we get it. But the reason it doesn't matter is, remember we said the Frank's motion was really devoid of any legal citations. If you note, basically they say this is probable cause, and then they give you all these citations to cases, to the Constitution, to the Indiana State Constitution, as to what probable cause is, whether it's met, and why there is no Fourth Amendment violation. And that's why it's important here, because the Fourth Amendment violation against an unreasonable search and seizure is what this search warrant is about. They're bringing it all back. I appreciate this. I think this educates the public who may or may not be reading this motion. It's going to be a lot shorter to read than the 135-page Frank's motion that the defense filed. But it's an education on why this search warrant matters at all, and all the citations of where you can go look for the sources of what the standards are.
And I know some of you are out there thinking, how can it not matter if the officer lied in the affidavit, even if it's about things that aren't really that relevant? Let's assume that every single mistake, error, and omission that the defense mentions in their document is an outright lie. That the officer who wrote the affidavit out lied. There's a few things that are important. Number one, that is not the standard. The standard is, are the truthful things in the affidavit enough to have probable cause? We know one thing the officer definitely did not lie about is that there is a report from a conservation officer in 2017 where Richard Allen put himself on that bridge. If that's enough for probable cause, it's enough for the search warrant. So for the purposes of the search warrant, no, it doesn't matter that he lied. But I'll tell you where it will matter. In trial. And that's why we keep going back to this. In trial, we have told you this before. Statements you make outside of court are hearsay. You can't bring them in unless it's to do something like challenge credibility. So when officers testify on the stand and they're testifying about things, the defense is going to be able to stand up and show that affidavit and say, right here, where you said he was bloody, this person didn't say that, did they? You lied about this, didn't you? You lied to a judge. That's how much you want to convict my client. You were willing to lie in an affidavit in order to get a search warrant. That's how committed you are. How can this jury trust anything you said when you said this lady said he was wearing a light blue jacket and she only said he was wearing a light jacket? And she might even said it was tan. Tan's not blue. How can this jury trust you? that's when it's going to matter. It's not that it just goes away. It's that for everything you do in court, there is a standard and there is a way we look at things, and there is a process. And this process will play out, and it will play out in court in front of a jury if Richard Allen, who, by the way, I just want to remind everyone, apparently has confessed to the murder to his wife
on more than one occasion.
On more than one occasion, if he actually goes to trial, all of this will play out then.
Absolutely. I have nothing more to add except remember what the standards are and don't be distracted by arguments in the wrong order. It really is putting the cart before the horse. There is a reason there is so much pre-trial time before you go to trial. There are a lot of things to hash out before you get to the trial. The trial is important, and all of this will come out. None of this is being swept under the rug. None of this is going to be forgotten. We've said this before. Basically, all the case files, there may be some motions about what can come in and what can go out, but nothing is going to disappear because of a ruling on a motion about the probable cause in an affidavit.
And if you don't believe us, if you think this motion is more significant than it is, ask the defense. And here's how you ask them. The bullet in this case is a critical piece of evidence. It connects everything else Richard Allen said about being on the bridge, basically being bridge guy, wearing the clothes. There's a bullet found with the bodies. According to the forensic evidence, which will be challenged at trial, have no doubt about that. And I guarantee you that if this goes to trial, they're going to put a forensics expert who was going to crush the defense's soul with the bullet analysis. When they do the tool marking analysis on that bullet, all this stuff you've heard about how, oh, that's not really science, will destroy them. They will absolutely destroy them. And they will show that, no, actually, this is good science. And here's all the markings, and you can see them, and here they are, and here's the computer recreation, everything else. They're going to do that. But that's why the bullet is so important. You can exclude the gun if you can kick out that search warrant. Think about how big that would be. Think about how significant that would be if you could get rid of the gun. Then you don't have the tool marking analysis anymore. And there may be other evidence that came of that house that we don't know about yet, that the prosecution's keeping close to the vest, that could be incriminating. There could be all sorts of stuff. Think about how important that would be and put yourself in the defense's shoes. If you had a viable argument to exclude that evidence and you wrote a motion to exclude that evidence, would you wait till page 105 to make your argument? The answer should be, for all of you, no. In fact, you wouldn't even worry about the Odinite stuff at this point. You would hammer that thing into the ground. You would have so many cases from Indiana where evidence just like this has been excluded under just like these circumstances. And they didn't do that. And when they didn't do that, they told every single one of you, this is not a serious argument.
And I hope this gives you perspective as to why we've gotten this 135-page motion. They can maybe explain away the confessions as a crazy man ranting in jail. Maybe they can say that he, when he talked to the resource officer in 2017 and in 2022, he had his times wrong, that he wasn't really on the bridge. The bullet is going to be something other than his own words putting the nails in the coffin for him. If they need to get rid of the gun, they are doing everything they can, because this is the only piece of evidence that we know of so far that is putting the girls with him. That's not his own words. This is a devastating link. This is a devastating piece of evidence. That's why they are throwing a freaking Odinist 135-page motion at you. Do not be distracted by what's happening. They are pulling out all of the big guns, pun intended, to get rid of the big gun. It's not going to succeed, but that's why they're doing it. This is a damning piece of evidence for them. And a really quick note, this is jumping ahead. This is not for the purposes of this motion, but I know a lot of you are thinking, that's junk science. It was an unspent bullet. It wasn't, no one's ever been convicted on this type of evidence. First of all, I don't think that's really true. Second of all, that is going to be battle of the experts. We've taught you guys about experts before. This will absolutely be battle of the experts, because I promise you the defense will also try to put on an expert who says all of those arguments. And what is supposed to happen is the jury is going to hear the expert from the prosecution about that bullet, and then the defense gets to rebut that expert with their own expert, and they get to duke it out. And you get to hear all of the arguments for both sides, and at the end of the day the jurors decide which expert they think has the better argument. And by the way, even if no one's ever been convicted based on a bullet, and I don't think that's the only evidence there is, there's no like preclusion that just because no one's ever been convicted on one type of evidence that it can never be done again. It might mean that you have to make a greater showing because it's a new type of science, or the jury is not used to it. Like, all of us understand what it means to have a DNA, fingerprint on someone's windshield, but we didn't always understand what that meant. The first time we used DNA or fingerprints to convict someone, you betcha there were a lot of questions about what that meant. And so there's no preclusive effect that just because a piece of evidence hasn't ever been used before can't be used now.
And one thing I would just say, when people say no one's ever been convicted on the basis of this evidence, Richard Allen's not going to be convicted on the basis of this evidence. This will be one piece of a circumstantial case that will connect him. A tapestry will be woven, and one big piece of that tapestry will be the bullet. So if you look at the bullet, and an expert can say, look, I can't say with 100% certainty, but I can say, with a fair degree of scientific certainty that this bullet cycled through that gun. That is a piece of circumstantial evidence that when you combine it with his own words, putting himself on the bridge, putting himself in the clothes, and oh, by the way, confessing to the murder, when you combine all those things together and maybe other evidence about the prosecution, a jury can reach a conclusion. And I'll just tell you, some of us may or may not have access to experts who may or may not know information about bullets and the markings on bullets, and may or may not know that when a bullet is cycled through a magazine and ejected from a gun, it can be traced to the gun. We're going to see all that. It's going to come out in a public trial. So I would just say, be patient. I will tell you one thing: prosecution is not worried about it. Prosecution feels very confident that ballistic evidence is going. If it stays in, if this Frank's motion doesn't succeed, then they're going to be in a really good place. And look, once the Frank's motion fails, once the district court or the trial court denies the Frank's motion, it's going to be interesting to see what happens here, guys. I know everybody thinks we're going to trial now with Odinism. Maybe we will. I still don't know. The confessions.
They're
Maybe
doing
you
everything
can
they
convince the
can to
jury.
toss out the confessions and the gun. And when they can't do this, we see this all the time. It's a constant, think about a scale. The defense is doing everything they can to tip the scale in their favor. And when those things fail and it so heavily weighs to a probable conviction, then the calculus changes for the defense.
And I don't think there's been a decision made, and maybe someone in the chat can clear this up, about the death penalty. I think Indiana has the death penalty, but very rarely executes anyone. But I don't know if the prosecution has said they're going to seek the death penalty. And if they are,
I don't think
then they can take it off the
we've
table.
known that yet. And by the way, at least in my experience, I know with like death eligible cases, you can be pretty far down the prosecution. Like, you can have charges. It just has to be some period of time before the trial that you make the motion that it's going to be a death penalty case. So this may be something that they're running up the chain or trying to decide, really maybe trying to see how these motions play out, whether they need to pull that card to kind of force either a guilty plea or take it off the table if they're going to a jury trial and not to have death on the table. That's a very touchy subject for a lot of potential jurors. So it's possible that they're still debating it.
I'll say this: if the defense, if their description of the crime scene is anywhere near correct, and what the girls went through is anywhere near correct, this is one of those, if you're not going to seek it for this one, just go ahead and get rid of it, Indiana, because you shouldn't be seeking it for anybody. And I hope they do seek it, and I hope it leads Richard Allen to give this family some peace. A lot of y'all at CrimeCon, you probably ran into them. They were there, still advocating for their girls. And it would be nice if they didn't have to sit through that trial. And if they didn't have to hear detailed evidence in excruciating minute by minute detail of how these girls died and exactly what they went through.
And by the way, I want to say, we talked about how the victims' families and the victims were re-victimized again by that Frank's motion. I do want to kind of applaud the prosecution because I think they said volumes about the victims and how they cared about the victims without ever actually saying the specific words, because to do so, I think would have drawn more attention to it and probably just re-victimized the family members again. And the way they stuck to the law, stuck to bullet points, stuck to the very clear facts that are in this case and made it non-confusing. You don't have to be a lawyer to read this filing. It's very clear. It's very clearly written. I think by doing that was a way to honor the victims and to recognize that this case isn't just about what all of us want to know on the outside, that they recognize the victims are at the center of this case. And that's the way they've been going about this case. At times, it may have, led to some curious decisions in terms of press conferences along the way. But I will say the prosecution, which is not the people who've been making press conferences throughout the investigation over the past 5 years, the way they are writing their motions, I think, is speaking volumes already. With that, Brett, is there anything you'd like to add before we sign off? I'm sure it will not be the last time that we talk about even this motion, and certainly not this case.
The only thing I'll say to everyone is, I saw some people who responded to our last thing on this on Delphi and said that we were biased. We were so biased because of the way we reacted to the defense's filing. You should be biased against people who claim there is a ritual sacrifice at the heart of a case. You do not have to start from equipoise on that. Start from a place of skepticism. Make them prove it to you. We have been down this road before, and it doesn't lead anywhere good. It may be that they can prove this. Make them prove it. I am absolutely biased against this claim. It has to be proven. There will be a trial. Be patient.
Yes, patience indeed. And I just really want to note how important what Brett just said is. Remember how maybe even just a month ago, I think on some chats or some lives, everyone was saying the fact that the internet community or the true crime community wasn't coming to the Richard Allen is innocent defense speaks volumes because he's so clearly guilty. This was just a month ago. And then after the Frank's motion filing, I'm seeing everywhere people posting like, well, now there's definitely reasonable doubt. Somebody's been lying. Somebody needs to explain to me, because they are just taking full cloth everything that's being fed to them and clinging onto it as true. Very important note here. The motion, let me start that over. The prosecution's response to that Frank's motion is not a rebuttal to the claims made in the Frank's motion. Hear that again. Nothing in this 8-page response is actually in response to the wild allegations that the defense has made in their Frank's motion. So you are not getting both sides of the story. So those of you who are like, well, I let the defense speak and they didn't say anything about Odinists, so therefore the Odinists must have done it. You have not heard it. You will hear it at trial if it comes up there. But do not mistake what what this filing is. This is not a rebuttal to the allegations. It is sticking to the law and the standards and what is before this court right now, which is whether there's probable cause in the search warrant affidavit for Richard Allen's home. That's it. It is not responding to Odinism or potential misremembering of different comments in police reports. None of that has been addressed yet. So if you read the 135-page motion and you think, there's a lot there, I'm going to need to learn more. You haven't learned more. Just remember that part. You haven't learned more because the prosecution has not told their story yet. So reserve judgment until you hear the other side.
Amen.
Well, This has been a really interesting discussion. I thought, when we walked up here to record tonight, both of us are pretty tired, and we're like, this will be a short one. It's an 8-page response. We'll get this done. Snipper snapper. And an hour later, we're still going hot to trot. But Brett, that's partly why I love doing this show with you, because I love discussing these things with you. And I love that our listeners want to know all the arguments behind it and have open ears to hear all of this, because I think we're saying something that not a lot of people are saying in the media or in other podcasts right now. So we hope we've given you a different point of view to consider when looking at these filings. And remember, we are still early in the journey of the prosecution of this case. This is still incredibly early. There are a lot of steps yet to be made before we even begin to enter the trial phase. With that, and until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs.
Yay.
Yay.
It is our first Post Creator of the Year episode. I can prove it. It's right there.
Stop it. I just want you guys to know, when I came home, my son was like, Mama, I heard you won an award. And he was like looking at me, he goes, where's the award? I said, Mr. Brett took it.
So I have video. I had a couple like top moments in life in CrimeCon.
Tell us about it, please.
Sorry,
stop stroking it. That's so weird, man. That's so weird. I'm just gonna.
Glad this is on video, Alice, because that could be taken the wrong way. So my wife was watching the award ceremony on television with my daughter, because it was like $500 if you wanted to bring a guest. So she was watching it with my daughter and recording her, and she was watching it. And when we got up on the stage, she goes, "That's my daddy," and it was like, "Oh, this is so amazing!"
You have that on video?
I have it on video, and it's amazing.
So when I came home, my son had drawn. He had watched it too, and he like got really giddy, because I don't remember what I said, but I think I thanked my husband for being at home with all the kids, and he goes, "I'm kids." And he had drawn a trophy. I don't even know that he knew what a trophy was, and he wrote Alice in it, like not mom, like he wrote Alice, and he drew like all these little hearts around it. And then right next to the trophy, just keeping it humble here, he drew a picture that I didn't know what it was. And I said, Bud, what is this? That's a cool trophy with Mama's name on it. What's that next to? He goes, that's the washing machine, because you wash a lot of things. And I said, thanks, buddy. Really appreciate it.
Well, some of y'all may have met my daughter, because we walked around a little bit, and a couple of you, we were going back to the elevator, and I don't look, we're just normal people, right? And that's important to remember. But there were a couple people who were off the side, and they were like whispering. One was like, I think that's Brett. And so I was like, hey guys. And of course, then they come and run over and they start like screaming and stuff. And then we get on the elevator and they're acting like I'm someone that matters. And they get off the elevator and my daughter's like, why were they acting so silly? And I was like, I don't know, baby. And then I got the award and she was like, did the silly people give that to you?
Oh, did the silly people give it to you? That's really sweet. That is really sweet. But
all right.
Yeah, we got to go sleep. You know what? You know what's crazy? I have like a bunch of depositions I need to go prep for. I'm so tired. I
got a hearing at 8 tomorrow.
You do? God, we're crazy people. Why are we doing this?
I don't know. It's a great question. I'm just glad, there was a moment there where we thought we were going to be on television again, and we're going to do television at 7, and then we're going to do this at 8:30, and we're just crazy people. Luckily, they didn't need us.
I know, right? Luckily, they didn't need us. I was kind of relieved when they did not contact us to go on TV again, because, guys, I really like showing up looking like this for you guys.
Yeah.
You're my real friends. You see me how I really am.
This is what I like to wear when I'm on video.
And I just want to let you all to know, you guys gave me the most amazing shirts at CrimeCon. I love cheese. I was going to wear it tonight, but my baby Brittany sleeps in my closet, and my t-shirts were all in the closet. So just know that I wanted to wear a t-shirt, but it was in baby Brittany's room.
Look, and Jamie's asking if it was scary. I assume she means being on TV. I was completely terrified of it. I don't know if you guys could tell how nervous we were, but I mean, I was because I just, television is completely different than podcasting. Like, if you
For one, your face is on the screen. It's terrible. like every little, thing you do. And also you can't see
I was like,
anything
how
that's
do I
happening.
smile? And everything, yeah, it's like, and everything you do is delayed because there's a little bit of a
Yeah.
delay. So, anyway,
Yeah, I was really nervous. I was like super nervous. And also I kept texting Brett like the hour before. I was like, I'm nervous. I'm nervous. I know this isn't helping your nerves, but I'm
I was like,
nervous.
it's fine, it's gonna be fine, it's gonna be fine. But the whole time I was like super nervous. Anyway,
Oh my goodness. Anyways, thank you guys for watching those. It was you I had no idea you guys knew. I didn't realize that, some other people had posted it,
we
but
didn't
we
tell anybody just
totally
in
didn't
case it
tell
was
you guys
terrible.
because what if we just like froze?
Yeah, yeah. I mean, the first question's like, "What do you think, Alice?" Or "What do you think, Brett?" And I'm like, "Yeah, you're probably right." Silent. Like, okay, I guess we'll move on to the next question.
So
Yeah.
weird. Okay. Yeah, no, but and this is the real story. 7 o'clock our time is like peak chaos time in our house.
Mhm.
Three like my house, everyone there was literally food all over the ceilings. Kids were screaming. My kids didn't even finish dinner. I made them go upstairs to the bathtub, which is right above where I was recording, and that's why I thought they were gonna fall through the ceiling because they were jumping so loudly. And I was like, please, please, please. I hope they can't hear this.
Yeah. Yeah, it was something. But you guys were great. It was great to have Murder Sheet on there. It
They
really was
were.
calming that they were
It
there.
was like a security
It
blanket. I was
was a
like, "If
security
we don't know
blanket.
what to say, Kevin and Anya will know the
Yeah,
answer, and
they'll
it's
be fine.
okay."
They'll take over for us. It'll be fine. So it was really great to have them. They're so
Oh,
awesome.
oh
So
my
we love
goodness.
them. Have to have them on again sometime.
Oh, we
But
do love them. And by the way, just so you guys know, like all of these motions and filings, they're like always the first ones to send it to us to make sure we
oh
get them
yeah,
and read them. By the way, like that just shows you how generous they are. They're not keeping it to themselves. They want us to read it. So I know this is not new information for those of you who listen to Murder Sheet, but I just have to like give them a shout out again because it's the opposite of certain people we know on the internet.
oh yeah, they're amazing. I mean, they really are. They're great. They're great. I know
Oh,
they can be fiery on certain things, and some people don't like it. But man, they are just so gracious. It
yes.
like blows my mind. Everything we said, if you guys listen to our episode where we thank people, I mean, it's all true. I mean, all those people have just been
We both
incredible.
almost cried. I don't think we videoed it. It was just us recording it. We didn't invite you guys because we wanted it to be a surprise.
Mhm.
But we were, like, choking up and, like, looking at each other recording it.
Oh, yeah. I mean, yeah, I got a lot of love for a lot of people,
I love
including all of
everybody.
you. All of you guys who stick with us no matter what. You're
Yeah,
amazing.
we do. Meeting you
124
guys
of you still on here as we
124,
like,
that's a lot.
yep.
Meeting so many of you guys at CrimeCon was, like a dream come true. Like, it really was. It was so awesome. You guys are it's weird because it's like we're friends, man. And we are friends now that we've really met too.
Yeah. And you know how it is. I mean, egos, whatever, are fragile. It is so easy to get down on yourself and be like, I don't know, is this really, are we doing any good? Is this terrible? Does anybody like this? Like, why do people listen to this? And just your constant sort of lifting us up. I mean, it's so easy to get down. And there's always somebody who wants to attack
Well,
you,
I
right? There's
mean,
always
all
somebody
you
who
have
wants
to
to say
do is
bad
read our
things.
reviews to know that, like,
Yeah.
yes, we let it roll off our shoulders, but it's not really fun to be called the B word repeatedly, over and over and over. It's not fun.
Yeah. If you've
It's
been
not
on
something I
Twitter,
wake up
man,
wanting to
good
do.
Lord.
Whew.
Twitter and Reddit, it's like people come with the knives,
Red
man.
Okay, so
They
I have
just
a friend who didn't know that I do a podcast, and she found out, and she did the terrible. She Googled me,
don't,
and
yeah.
she texted me. She goes, "The internet hates you," and I was like, "I know the internet hates me."
Yeah. I mean, it's if yeah. I use
And
the
for
block button or the mute. I mute people because I don't want them to feel. I don't want them to get the
sad.
joy out of being blocked. So I just mute them and never
I'm
talk to
terrible. I read all my muted texts. I really
them.
should not do that. That defeats the purpose of mutes, but I definitely do it. But don't worry, those of you who didn't make it to CrimeCon this year, we are definitely going to Nashville, and it's in May, so it's less than a year away. So I think some people didn't know if we were going to be there. We're planning to be there,
Oh
and we
yeah,
hope
we're
to
gonna be
see you
there
there. It's so
with bells
fun.
on. And as soon as we get our code, we'll share it with you. I
I
already emailed
assume
them
it's the
about it.
same prosecutors because I know a bunch of you
I
already
assume it'll be
booked. Way to go!
prosecutors. Yeah,
I haven't booked anything, so if you guys
I haven't
booked up
either.
all the
Well, I'm waiting
hotels.
for them to officially invite us. I assume they will. I mean,
Oh, I
since
guess
we
they haven't
won
invited
an
us
award. I
officially.
just want to point this out again in case you missed it. I
Uh,
wonder wonder if we'll get to give one. Maybe we'll get to give the People's Choice Award next year. That'd be fun.
Brett,
If we got to
put
do
that
that.
down. You are
Put what down?
ridiculous.
What are you talking about?
Put it
This?
down. Come on.
This?
You know, someone's going to
Fine.
make a meme of it and someone's going to give you a 1-star review for being,
That's fine. He's got a big head now, and your podcast used to be awesome. Now they
You
do
do have a
talk to
pretty
their
big
award.
head, though, but it's just because
I
you're
have
smart.
a huge head. I can
Because
barely
you're
find
smart.
hats to fit me. It's rough.
Oh, we are
Rough.
just on total tangents. You need to go get ready for your argument. I need to go get ready for my deposition, and we need to keep being lawyers.
It's been a long time since I took a deposition.
Okay, I'm going to take a poll. Well, how long do you think Brett's going to have it before he lets me have it for one day?
It's so heavy. It's like a workout thing. It's like my workout.
Oh my gosh. It's not a workout thing, which shows you how much I need to work out.
The last deposition I took, I threatened to arrest the other lawyer. I don't know if I've told that story or not.
Someone threatened to arrest me during a deposition, which was like
Really?
ridiculous. I wasn't doing anything. I was literally existing. They just
He deserved to be arrested.
They had really bad facts.
Mm.
And they were trying to get me arrested so they couldn't get the bad facts out. But, you know, it is what it is.
It is what it is. All right, guys. Love you all. Y'all are awesome. Don't forget, we'll be back tomorrow night. So
Oh, I'm so tired. But
Halloween
we'll be back.
episode 4, where this will once again make an appearance.
Oh my
We
gosh, guys, I'm
can-
going to go break into Brett's house so I can take that away from him.
Yes. So I'll see y'all tomorrow.
Indeed. See y'all tomorrow.
Bye, guys.
Bye,
Love
guys.
you. Mean it. Bye.
Bye.